Professor of International Law at the University of Dundee Centre for Energy, Petroleum and Mineral Law and Policy, and I practice with CMS Cameron McKenna in London and Edinburgh. We have a fantastic panel for you. Before I introduce the panel and the panelists, I'd like to thank the program committee, especially Danga Kamau, for convening this panel and helping us get organized. And special welcome to Benjamin Ferenc. Very pleased to have you here, sir. May I please ask you to turn your cell phones off so that we don't have any disturbing noises from the audience. Of course, we hope to have some noise from the audience later on when we get to the Q&A. Now, we have opted for the roundtable format in hopes that this will foster a lively discussion among the panelists. And my role as moderator is a modest one, which is to set the stage and to steer the discussion. Now, there appears to be a negative connotation associated with the term intractable conflicts. By describing a conflict as intractable, are we not ascribing a defeatist meaning to it? Is it too negative? Should we therefore avoid its use? The program description, in the drafting of which neither the panelists nor the moderator were involved, would seem to confirm this negative connotation, where it suggests that intractable conflicts might, quote, compromise international law, end quote. Now, this panel will take a critical look at the issues surrounding intractable conflicts by examining and perhaps questioning the very notion of intractable conflicts, and by highlighting how conflicts that might seem intractable at first blush actually have seen positive developments and even outcomes through the use of existing international law processes. Therefore, this panel is not all about doom and gloom, or how international law has failed in practice. Now, Doom and Gloom is the lead single from the 50th anniversary compilation album by the Rolling Stones. And I was planning on mentioning this, and Matt Kinnear stole my line yesterday by quoting from the Rolling Stones. But according to the lyrics of that song, when all I hear is doom and gloom and all is darkness in my room, through the light, your face I see. Baby, take a chance. Baby, won't you dance with me? So maybe at the core of this issue is there a baby to dance with? Maybe the babies won't dance. So why is that? The issues that we will be discussing on this panel will be approached by the panelists from different perspectives, and by relying on their personal experience with what many might view as intractable conflicts across the globe. So first of all, we have the government lawyer. And we're pleased to have on this panel Catherine Almirfar, who served as counselor on international law in the US Department of State, on leave from Debevoise and Plimpton in New York, where she's a partner. Then we have the perspective of the adjudicator. And we're honored to have Rüdiger Wolfram, an arbitrator and former judge and president of the International Tribunal for the Law of the Sea in Hamburg. And he's with the Max Planck Foundation for International Peace and the Rule of Law. Then we have one of the most prominent counsel before international courts and tribunals with us, Paul Reichler, who's a partner and chair of the International Litigation and Arbitration Department at Foley Hoag here in Washington, D.C. And last but not least, we will present the perspective of the business advisor in the context of intractable disputes. And so we welcome Caitlin Thomas, who's principal at Caitlin Thomas PC Global Directives in New York. Now, in aid of our discussion regarding intractable conflicts and international law, we will be referring primarily to the following conflicts in the various regions of the world by way of practical examples. again, without prejudice to the question of whether the panelists agree that these constitute intractable conflicts, properly so called. In Africa, we have Abyei and Sudan, we have Western Sahara. In Europe, we have the Turkish occupation of northern Cyprus. In the Middle East, we have, of course, the situation between Israel and Palestine, and in the news every day, sadly, Syria. And in Southeast Asia, we have the Chagos archipelago, and we have Kashmir between India and Pakistan, as well as the South China Sea. And then finally, in Oceania, we had the long-running dispute between Timor-Leste, as it is now called, and Australia. And last weekend was Easter weekend, and of course we were reminded in a somewhat painful way of what we still have to solve across the globe. Now, at the outset, it should be mentioned that international law lays down certain ground rules in this context. These ground rules seem undisputed. First, the principle of the sovereign equality of all states is expressed in Article 2, Paragraph 1 of the Charter of the United Nations. Second, Article 2, Paragraph 3 of the Charter obligates all UN member states to, quote, settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered, end quote. Third, the freedom of choice of means of settling disputes is enshrined in Article 33, Paragraph 1 of the Charter, which provides a range of means or options for settling disputes. And that provision reads as follows: the parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall, first of all, seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their own choice, end quote. And Article 279 of the UN Convention on the Law of the Sea refers to the latter two provisions. Now, at the outset of our discussion, it might make sense to try to define or delineate our topic and to investigate the roots or essence of intractable conflicts. How are intractable conflicts different from other conflicts or disputes? As U.S. Supreme Court Justice Potter Stewart famously stated in describing his threshold test for pornography in Jacobellis v. Ohio in 1964, quote, I know it when I see it, end quote. But does that work for intractable conflict? What do we mean by conflicts in this context? And is a conflict interchangeable with a dispute? Article 33 of the UN Charter employs the word dispute and not conflict. Is the PCIJ's classic Mavromatis definition of a dispute of any use in this context? It reads, quote, a dispute is a disagreement on a point of law or fact, a conflict of legal views or of interest between two persons, end quote. And note that the definition of a dispute by the PCIJ refers to a conflict of legal views. Now, after attempting to define what constitutes a conflict for purposes of our discussion, we will address the question of what makes a conflict intractable. So let me first ask Catherine, how do you view this potential difference or maybe overlap between conflicts and disputes?
Thank you, Peter. It doesn't seem to be working, but I assume everyone can hear me. Oh, good. Okay. Thank you very much, and thank you for organizing us here. Now, since I've been asked to don the hat of a prior life, when I had the distinct privilege of working with my brilliant colleagues at the Legal Advisor's Office at the State Department, some of whom are here today, I have to say this, and I haven't said this in a while, with this caveat, that these are my own views and my own personal views and should not be attributed in any way to the State Department or the US government. So with that done, so turning to the question at hand, so conflict on the one hand, dispute on the other. To the extent there's a distinction, it's one beloved only by lawyers, but this is the right audience to have this discussion. I think it won't surprise you to learn from a government lawyer perspective, it's the context, and that the meaning of the words in diplomacy, and the touchstone of diplomacy, by its nature, involves careful word choice. And the specific words used by governments to describe the tensions between them, usually, not always, usually, are very carefully chosen to communicate the underlying message. Now, in terms of the language of conflict versus dispute, I think, again, with this caveat that diplomacy is necessarily context-specific. As a general matter, I think the language of conflict implies political impasse, in some instances risk of violent confrontation, so serious. And the language of the dispute, in my mind, has more of a legal context. And it could be one conflict, many legal disputes. And that's one distinction that I see. Now, when it comes to describing what we're calling, I think here, intractable conflicts, and I'll get to intractable in a moment, I think the sensitivity associated with how to characterize high-profile, highly sensitive agreements between states is acute. And just a recent example, you witnessed the alarmed reception from other countries, from the world, when President Trump warned of a risk of a, and I quote, major conflict with North Korea. So these are, the words matter, and this is something that I think, in the particular context of intractable disputes, the words matter. Now, one nuance on this is that in the boundary area, it's still absolutely right that the words matter. One other overlay, in my experience, some of boundary claims are so long-standing and politically sensitive that from a government's perspective, the idea of even acknowledging that there is any kind of conflict or dispute is taboo. So instead, we have a situation where each side, let's say, blesses an island or a rock at issue with its own name, affixes that name to its maps, and moves on, never acknowledging the other side's claim. The idea being to engage in verbiage of dispute implies that there's some merit to the other state's claim. So again, words matter, what is being communicated is important, and I think of the term conflict as definitely something that, depending on the context, has diplomatic baggage. Now, I think of the term dispute stands somewhat in contrast, and again, that's the legal context. Peter, you've talked about that. Now, dispute for the ICJ is pivotal. So under Article 38, as you know, the court statute, the function of the court is to decide in accordance with international law such disputes that are submitted to it. So there's a function that's being played. It's a very important jurisdictional function that's being played. Again, in that context, words matter. And then just let me turn briefly to the idea of intractability. Now, and you've seen from the description, is intractability determined by subject matter? Is it about sovereignty, self-determination, human rights? And I actually resist that. I think that there's many factors that lead to the concept, if there is one, of intractability. But I don't think it's one factor, one topic that determines it. And by example, there is disputes, for example, that are intractable in the sense that they have proven difficult to resolve. And one example that came to mind is that the US and Canada dispute parts of the Beaufort Sea off the shore of the Canadian territory of Yukon and Alaska, but no sense in the world view, or I think in the parties' views, is that an intractable conflict. There's hopefully no prospect of this dispute sparking a violent confrontation, and it doesn't seem to be impacting in a meaningful way the ability of these countries in terms of relating. So intractable needs to be something other than not susceptible to resolution. And in my mind, I think it's disputes that are both difficult to resolve and high stakes. What do I mean by that? I mean that protracted, susceptible to violence, politically or economically sensitive, with regional, global implications in the sense of threatening global peace and security. So it's a plus factor in terms of that. And I think we're going to get to some examples later, but think about the Beaufort Sea dispute and compare it to Russia and Ukraine and Crimea, compare it to the Syrian conflict. I think you start to see in real life a lot of distinction playing out there.
Thank you, Catherine. Before we get to the intractability of what we are discussing here, Rüdiger, as a judge and arbitrator, how do you see this pair, conflicts and disputes? Is it just nomenclature, or does it have any meaning for you?
Thank you, Peter. Thank you for having been invited. And as Catherine has just pointed out, I speak for myself and nobody else. I'm certainly speaking today as an academic who happens to be occasionally involved in adjudication. Having said that, for me, the term conflict has a broader meaning than legal dispute or dispute. But there is a connection between the two. Most conflicts, I would even say nearly every conflict, contains at its core a legal dispute. Even, as we heard yesterday in one panel, the conflict concerning climate change. There are certain legal disputes involved. And that leads me to my second consideration. if it is possible to single out the legal dispute, to formulate, to paraphrase it properly, and to solve it, this is the first step in solving a conflict. And in that respect, there's an interrelation. But we should not speak about intractable conflicts. Conflicts are perhaps today cannot be solved, but they may be solved later, depending on a change in perception of the parties, perhaps in the changing in the composition of a government, in different value assessments, or changing circumstances. If you look back to the middle of the 1980s, you would have sworn that Germany, its conflict, would never be united. I felt that until 1988. In 1989, it was different. It was due to certain new perceptions, new developments. Therefore, let's not overemphasize conflict as everlasting. And that is giving a glimpse of hope to West Sahara or South and North Korea, etc. You don't want me to go into intractable, but let me say a couple of words about dispute. First of all, as Catherine has already pointed out, a dispute is important for two reasons in adjudication. First, this is what adjudicators have to solve. That's what you mentioned. But I believe there is another aspect. The legal dispute also defines the scope of jurisdiction. What do I mean? The dispute is defined by whom? First and foremost by the application, I believe. And this was an issue which was discussed controversially in Mauritius versus United Kingdom, and not so much in the Philippines versus China. But that's a very important aspect, and in this respect I may say that the jurisprudence of the ICJ is not always very clear, but it has evolved in the last period. This is very important to have a proper understanding of the scope of a legal dispute, the disputes being defined a la Mavromatis with the modifications introduced by the ICJ and ITLOS later. Only if we define the scope properly, then from the point of a judge, you can look into whether the right documents have been presented, whether the, what should I say, the right arguments have advanced, or to put it the other way around, whether the tribunal or court should look for other or additional evidence. And therefore, it is necessary very much to look very carefully into what is a legal dispute to be solved. And here, the court or tribunal should not be overactive, trying to expand the scope, for this runs counter that it is for the parties to define the scope of the dispute, particularly the applicant. Intractability, I'll come to that a little bit later. Thank you.
Thank you, Rüdiger. Paul, the Council's perspective, when you look at the wider conflict, you are presenting legal claims before an international court or tribunal. Obviously, you're honing in on the legal dispute because that's your hurdle to establishing jurisdiction, I would take.
Well, for me, this question is not an abstract or a theoretical one, but it arises every time in a very concrete and specific context. The practitioner is approached by a state that feels aggrieved by the conduct of another state and wants advice on whether its legal rights have been violated, and if so, whether legal recourse to a judicial or arbitral forum is available, and if so, whether a vindication of its rights is possible or likely. In most cases, at least in most of my cases, the aggrieved state is smaller and weaker than its neighbor, has tried unsuccessfully to get the neighbor to change its conduct via diplomacy or persuasion, and lacks the means to coerce through economic, commercial, political, or military measures. But it has at least one important tool at its disposal: the ability to invoke international law. And it comes to you to find out if the law can be used to help it vindicate its rights and obtain its desired ends in whole, or at least in part. And it has asked you to develop a legal strategy and build a legal team to win its legal case. So the first thing you do, if you're me, is you call Alain Pellet and see if he's available to join the legal team and hope that he hasn't already been hired by the other side. But this specific scenario almost exactly describes every one of the most contentious cases that I have litigated: Nicaragua versus the United States, Georgia, Russia, Bangladesh, Myanmar, Nicaragua, Colombia, Mauritius, UK, Somalia, Kenya, and of course, Philippines, China. When a practitioner like me is approached by an aggrieved state like one of these, it's not my task to ruminate on the tractability or intractability of the dispute per se, or to speculate on whether it's in the interests of the international legal order as a whole for such a dispute to be litigated. My task is to help the client find a solution to its particular problem. And normally this means providing the best advice possible on the three questions that most concern my client. First, has my neighbor acted unlawfully in violation of my sovereign or legal rights? Second, is there a court or arbitral tribunal where I can go that would have jurisdiction over my claims? Third, what are the possible and likely outcomes? Or more bluntly, can I win? Aggrieved states, I hope this is not disappointing, but aggrieved states rarely ask you about the effects their case will have on respect for the rule of law generally, or whether their case might put too much strain on international courts or undermine respect for the rule of law. Now, to be sure, these are issues that are not unimportant to us as career international lawyers, but our first duty is to our clients. And what they want to know is, can we win? Now, winning does not necessarily or always mean achieving a complete victory and a final and favorable resolution of the entire dispute with the other state. As Judge Wolfram has pointed out, sometimes, in fact quite often, the legal disputes don't constitute the entire conflict between the two states, but only one dimension of a much larger political conflict that may be so difficult to resolve that some might even perceive that as intractable. But even then, a binding judgment or arbitral award resolving the legal aspects of the dispute in favor of your client can be very helpful to it, not only in itself, but also in regard to progressing toward settlement of the larger political conflict. Your client comes back to the negotiating table in a stronger position than before, with the law clearly on its side, and the other party having been declared guilty of illegal acts. Sometimes this will lead international opinion to weigh in strongly on the side of your client, bringing pressure on the other state and further enhancing your client's ability to obtain its objectives. And sometimes internal forces in the other state find its status as an international lawbreaker untenable and push for changes in its policies to bring them into conformity with the law. And the dispute is resolved, and your client's objectives are achieved in that way. And that, for example, is what happened ultimately in Nicaragua versus the United States. I think I can stop here for now and address some of the
Yep.
other cases in which these issues have arisen, perhaps in response to other questions.
Thank you, Paul. So, Caitlin, from the company's perspective, I would think that you would be more concerned when advising foreign investors and companies about the wider conflict. Is that right?
Well, let me first give some preliminary comments here, because the case that I'm going to be talking about is quite different from the cases that the other panelists are talking about. If you noticed, all of them are talking about states and conflicts between states and conflicts that have to be resolved using mechanisms that are applied by states or international mechanisms. Well, the conflict of Western Sahara doesn't involve a state versus state situation. One of the parties are the indigenous population of a non-self-governing territory, Western Sahara, and the other party is a state. And the problem is that there is no effective mechanism under international law for the people of a non-self-governing territory to prosecute their legal claims. And in this particular situation, I have never seen a situation in which the international law principles were so clear-cut in favor of one of the parties, and in which it was so obvious that the other party didn't have any rights under international law. In this particular case, the indigenous people of Western Sahara have every maxim of international law on their side: the right to self-determination, the right to use their resources, the right to prevent an illegal occupation by force of their country, the right to prevent human rights abuses in their country, the right to prevent the exploitation of their country by an occupying power. I can go down every single international law aspect of this case and show how the rights accrue to the indigenous people of Western Sahara and not to the other state, which is Morocco. Unfortunately, it's because of political reasons that Morocco has been able to withstand this conflict for so long and not abide by international law precepts. There are two countries, major countries in the world, which are backing Morocco and which prevent a resolution of this dispute on grounds that would accord the indigenous inhabitants their legal rights. So this particular situation is very, very different from the other situations that the panelists are going to be talking about. This situation does involve a lot of aspects of economic powers, because if it weren't for the fact that Morocco has been able to use the resources of Western Sahara in cooperation with a lot of Western businesses and corporations, perhaps this conflict might have been able to be solved earlier. But Morocco has used all the resources, the phosphates, the fisheries, etc., throughout the entire period of time in which Morocco has occupied Western Sahara, and the indigenous populations have not been able to have any means to prevent this under international law. So what has happened? Today, they have gone to the courts of various countries to prosecute their claims. And they've been successful in the European Union courts to get the European Court to interpret the various treaties between the European Union and Morocco to exclude products from Western Sahara. And they will probably be initiating other lawsuits that are similar in nature to try to prosecute their claims through these various courts. But they can't do it through the International Court of Justice, because only states can do that, or international organizations. They can't do it through UNCLOS, because again, they lack standing. Even though UNCLOS recognizes the rights of the people of non-self-governing territories to the use of their resources, they don't give any effective way in which these people can have standing before UNCLOS to prosecute these rights. They don't have the rights to go in any of the other fora that are available, or even to appear before the UN General Assembly, because they're not a state. All right? So there are no mechanisms available to populations that are similar to the people of Western Sahara in order to vindicate their rights through current mechanisms of international law. As a result, the only thing left to them will be armed conflict or terrorism. Unfortunately, that's the problem.
Thank you, Gaitlin. So let's go to the heart of intractability and what contributes to the complexity of these disputes is something that we just heard. We have state actors as well as non-state actors who lack standing. Now, according to Webster's dictionary, intractable means not easily governed, managed, or directed. And as this definition confirms, intractable conflicts are not necessarily unresolvable conflicts. A website, which is not a legal website, called Beyond Intractability, defines intractable conflicts broadly as, quote, those that lie at the frontier of the field, the conflicts that stubbornly seem to elude resolution, even when the best available techniques are applied, end quote. Now, in international law, this raises the question of what are the best available techniques, and in what situation which technique should be applied. Now, can we maybe identify objective common elements of an intractable conflict? Does it help to place intractable conflicts into separate categories, such as treaty-based intractable conflicts and non-treaty-based intractable conflicts? And does each category call for a distinct approach? So I'd like to invite Rüdiger Wolfram to address that first, please.
Thank you. I warn you, I may take a different approach to that. First and foremost, as Peter, you indicated at the beginning, disputes are governed by Article 2, Paragraph 3 of the United Nations Charter. Therefore, we should be a little bit careful before we declare a conflict or a dispute to be intractable. It might be contrary to Article 2, Paragraph 3 of the UN Charter. Let me approach the question of intractability by grouping certain situations. I would distinguish intractable disputes according to a multilateral treaty, here the Law of the Sea Convention, intractable disputes according to a bilateral treaty. Then I would like to shed some light on intractability by inherent reasons. You will see I take a negative view in this respect. Fourth, I would like to touch upon intractability to non-appearing. That's a phenomenon which we have seen recently and we had before. And then finally, intractability by non-implementation or enforcement of a judicial decision. Let me start with the one thing which is quite familiar, namely intractability declared as such by the Law of the Sea Convention. If you open, in your mind I mean, Article 297 and 298 of the Law of the Sea Convention, particularly 297, there you will see that certain legal disputes cannot be brought before the mandatory dispute settlement of the Law of the Sea Convention, and that fits the definition of being intractable. I confess, 297 is not a masterpiece of draftsmanship. And I recommend to my students to put that paragraph under their pillow when they go to sleep, in the hope they would understand this in the next morning. I did the same with Latin vocabulary, which I found not so helpful, apart from being a psychological help. Being as it may, according to 297, there are certain claims which cannot be brought against the coastal state. That is the exercise of certain rights. I will not go into details concerning fisheries or scientific research. What is the reason for that? The reason for that is that in the exclusive economic zone as well as in the continental shelf, the economic benefits are reserved for the coastal state concerned. You may say that is not such a big issue. Don't underestimate that issue. I've heard in a recent case a developing country saying to be able to use our continental shelf economically is the finalization of our sovereignty. And therefore, intractability is very often the reflection of sovereignty, value differences, etc. Things which are so important for the state concerned that they don't want this to be decided upon purely on the law basis by compulsory dispute settlement. But let's move to 298. This is slightly different. Here you have declarations to make, and the declaration, for example, of the People's Republic of China, which is very succinct, is China does not accept any of the procedures provided for in Section 2, that's the mandatory part of Part 15 of the Convention with respect to all categories of disputes referred to in paragraph 1A, B, C of 298 of the Convention. You find the same in the Russian declaration, more elaborate but to the same term. This excludes delimitation and other things from a mandatory dispute settlement for the same reasons I mentioned before. However, to say this is intractability, although I use the word, is not totally correct. For if 297 is invoked, whether one has to invoke it is a different matter, or whether 298 is invoked, it leads you to so-called mandatory conciliation. Now you may say conciliation ends in a report. Therefore, there cannot be any binding decision and finally no enforcement. I believe it is one of the gravest misunderstandings of international law that we very much concentrate on the direct enforcement. Sure, it is a paradise for an international adjudicator when you see the behavior of Myanmar and Bangladesh, particularly Bangladesh, when they just copied the judgment and put it into their legal gazette. That's fine, that's perfect. But that's not the norm, although, as some have established, that 95% of the international judgments are properly implemented. I believe, compared to, I'm only speaking about Germany, that's much better than the implementation of national court judgments. You have just recently seen, perhaps if you had the newest news, that the former president of Catalonia has to be set free. A decision of the appeal court in Schleswig, and I'll see what is going to happen in this case. It's a highly political case. Be it as it may, these reports, as well as judgments, even if not enforced, have a very, very clear-cut message, namely, this is the legal situation. The enforcement is a second step. And to find clarity about what is the law, is what is called for, and therefore to distinguish between a judgment very strongly and a report like under conciliation is not very helpful. We have touched upon 297 in the Mauritius versus United Kingdom arbitral award, and in 298 in the South China Sea. For example, in the South China Sea, the arbitral tribunal has clearly avoided to do delimitation in respect of China, and has equally clearly avoided to touch upon military activities, although China itself said, this is not a military activity. The tribunal said, this is for us one, and therefore we don't touch it. Therefore, this has been fully honored. Give me 2 sentences. Non-appearance has nothing to do with intractability. It's just a failure to appear. The party, like Russia, in the Arctic Sunrise case, or China in the South China Sea case. Sure, states have the right to do so, but they remain parties, and in these cases, the arbitral award is, or the order of the ITLOS is still binding. And I've already said what I wanted to say about non-implementation. The statement, the legal statement, is on the table. And as far as the South China Sea award is referred, sure, it's only relevant between Philippines and China, but Indonesia has taken action on that basis by changing its maritime boundaries. Now, this is the continuing and very relevant aspect of enforcement or implementation. It's different from national law. Let me stop at that point.
Thank you, Rüdiger. Paul, we heard earlier that it could be useful to isolate the legal dispute from the wider conflict. But isn't it fair to say that the legal element constitutes only one aspect of an intractable conflict, and that the intractability derives from a given conflict having multiple aspects, including social, political, cultural, financial, and other aspects that contribute to making the overall conflict difficult to resolve? So how mindful do you have to be of those multiple facets in your role as counsel in a case?
Well, you have to be mindful of them because the client comes to you for advice. They have a problem, and they're hoping that you can help them develop a solution. So it's important to see the entire problem that they face and to appreciate how the legal aspects of it, if they are resolved, can either constitute an achievement in themselves. The successful resolution of the legal conflict can constitute a valuable achievement for the client in themselves, and further, how the success in resolving the legal aspects of the conflict can contribute to a facilitation of or progress toward a resolution of the wider conflict. So in order to give relevant and meaningful advice, it's important to appreciate the entire context in which the legal issues come about, and to give advice in terms of how to address those legal issues that that takes into account how the resolution of those issues that you're seeking might advance the client toward its ultimate objectives in regard to the wider conflict. I already spoke about how this was achieved in Nicaragua versus the United States. There are a couple of other examples. In Mauritius, UK, for example, the arbitration, in a very closely divided vote, the arbitrators decided that they did not have jurisdiction to address Mauritius's sovereignty claim, Mauritius's claim over sovereignty over the Chagos Archipelago. Nevertheless, the award and the strength of the dissenting opinions were critical to Mauritius in being able to draft a resolution before the UN General Assembly that received overwhelming approval and resulted in a request for an advisory opinion before the ICJ, which is now pending and will go to hearings in September. In Philippines, China, the South China Sea arbitration, granted, the legal issues, and particularly the legal issues that could be brought to the tribunal, which did not include sovereignty over features or delimitation of maritime boundaries because of the limited jurisdiction under the law of the Sea Convention. But those issues were resolved in a way that were entirely satisfactory to the Philippines. But that in itself was an important achievement for them in terms of the way they value their national interests. But beyond that, as Judge Wolfram has suggested, The way the tribunal resolved those legal questions was very important and very beneficial to Vietnam, to Indonesia, and to other states in the region, because now they are emboldened, and their will has been strengthened, and their capacity has been strengthened to resist China's 9-dash line claim, because they know it has absolutely no basis in international law. China itself, although it has adopted a posture of defiance publicly, has actually shown more flexibility than meets the eye, at least on a preliminary view. They have allowed the Philippines to resume fishing at Scarborough Shoal, which was one of the elements, an important element for the Philippines in the judgment. And in regard to an offshore oil development project at Reed Bank, instead of chasing away the Philippine vessels that were seeking to exploit what may be a rich oil deposit on the ground that China is sovereign because it's within the 9-dash line, China has now invited the Philippines to enter into a joint development plan for exploiting the resources there. Now, Philippines might rightly say, well, we don't have to jointly develop this with you because we alone have sovereign rights. But this shows there is some progress. We'd like to see much more compliance by China with the rule of law, in particular in the form of compliance with the unanimous award of a very distinguished arbitral tribunal. But it's too soon. Only 2 years have passed to consider that this is intractable, to use the language of this panel. It may be that the stiffened resistance to China's exaggerated claims, not only by the Philippines, but by Vietnam, by Indonesia, by others, the support for the arbitral award expressed by other regional players of great importance, Japan, India, Australia, Singapore, creates a context in which China loses by maintaining an outlaw position. And one hopes that in their wisdom, over time, the Chinese leaders will find a way to reach some sort of accommodation with their neighbors, rather than live in permanent enmity with them, that takes into account and respects their rights under the law of the Sea Convention, just as they must take into account China's rights. We may, too slowly maybe, but we may be moving in that direction. Time will tell. And what we must not do is give up and say, intractable, move on. I want to add one other thing, because Judge Wolfram said something that I think is extremely important, and that is often, well, everything he said is extremely important, but one thing is often overlooked. And let me tell you, enforcement power, this is from the standpoint of a practitioner. Judge Wolfram spoke from the standpoint of a judge. Enforcement powers are not all they're cracked up to be. Now, we as international lawyers, and I would imagine that every one of you at some point is asked by a student, a friend, a family member, why are you wasting your time? What is international law? There's nobody to enforce it. States can do what they want. It completely misses the point. First of all, again, I limit myself to the standpoint of a practitioner, 35 years of doing this. When states decide to go to court or arbitration, they know that the ICJ, ITLAs, arbitral tribunals, don't have enforcement powers. They take that into account from the very beginning when they make their decisions as to whether, as a political judgment, it is in their interest to pursue legal recourse. That's all part of the process of making the decision whether to sue or not. Now, Judge Greenwood said something very interesting at the beginning of his keynote speech yesterday. He compared the volume of cases, I think he was including ICJ, ITLOS, arbitration, interstate cases. He might have also been including investor state cases. He compared the volume of cases before international courts and tribunals before 1977 and afterwards. Well, the tremendous growth, the tremendous increase in the number of cases brought by states before all of these forums tells you, one, that states consider the system functional. They consider it useful. They consider it important, viable, necessary, even though these institutions lack enforcement or police powers. So international courts and tribunals perform their function within the system, perform their vital function by deciding the legal issues. And that in itself is extremely valuable, and the system is working. Now, in the vast majority of cases, enforcement doesn't become an issue because states do comply. There are many reasons for this, and why states do this is beyond the scope
I'd like
of this
to
discussion. Yes.
intervene and
Sure.
ask for the government lawyer's perspective on this. And how does the government lawyer avoid being bogged down by the intractable aspect of these conflicts? Again, keeping in mind that it's not just about the legal element, but there's more at stake.
No, that's right, and that's a very easy answer from a government lawyer perspective. Paul hinted at it a bit, which is it's never just legal. There are political, economic, social, human rights, military contexts in which governments have to make decisions. Witness what some call the very painful interagency process. But what is that designed to do? It's to bring to bear, and it's never purely legal. I don't think I've ever encountered in my portfolio as a lawyer at state that a dispute that I thought of as purely legal. So the context matters, and the decision-making matters in that context. When it comes to intractability, you asked if there were ways to parse this out in categories. I think you mentioned treaty versus non-treaty. I don't think of that as the way that I would think about parsing, because you have to look at it again from the perspective of governmental decision-making. One very useful metric or distinction between some categories is, frankly, the availability of compulsory jurisdiction, because that puts you in a toolkit. And with a different aspect of leverage, witness Philippines, China, South China Sea, versus Australia, East Timor as a conciliation process. Governments come to a potential compulsory jurisdiction, legal dispute situation very differently, as you may imagine, in terms of leverage, in terms of looking at the overall context, than one that is really in the toolkit of peaceful settlement, one more about a mediation process. And so I think that is one distinction that from a government's perspective in understanding the menu of options, the short of violent means, the menu of options of peaceful dispute resolution, that is the one cut that's very important. Now, Judge Wolfram and Paul have both talked about compliance. I would like to get into kind of what the effectiveness of the international dispute mechanisms. Okay, we can launch that. I'm cognizant of the time. I think as both of my friends have indicated, this meeting has had, from Judge Donahue, from Chris Greenwood, lots to say about the effectiveness of international dispute resolution. Judge Donahue spoke about the ICJ and noted the proliferation of international courts and tribunals not as a negative, but a view of healthy competition. And on one view of the world, general proliferation of international tribunals is a positive, as states have chosen to increase commitments to international dispute resolution. On another view of the world, this fragmentation is a manifestation of dissatisfaction with existing options. Now, in looking at this, I think effectiveness, the basic question of effectiveness, is a very elusive concept. And there's shockingly little in terms of quantitative literature that tries to define it, and more importantly, tries to measure it. What does it mean to be effective? And there are very few studies that are quantitative versus qualitative. But I think if you think about the measure as compliance, that's one metric. We hear all the time about robust ICJ compliance rates, absolutely, right? I think we hear less often about, in other contexts, some of the other international tribunal compliance rates. And WTO, ECJ, ECHR in a Helfer and Slaughter article, very good. One interesting piece by a political scientist in 2010 looked at all settlement attempts of disputed territorial claims in the Americas and Western Europe from 1816 to 2001. And I wonder if people think, do you think it was above 30% success? Raise your hands. All right, we have a jaded crowd in front of us. It was 22%. And I think that in thinking about success and compliance, we should be very nuanced in terms of the types of disputes. But effectiveness doesn't just have to be about compliance, and this really goes to the heart of, I think, what my colleagues here were talking about. It can instead be measured by providing states with neutral information about the facts and the law in a particular dispute, and that's another metric to think about. So from the government, just a few more minutes on this because I'm cognizant of the time, but from a government lawyer perspective, I think effectiveness has a threshold question of whether and how states make the decision to submit disputes to tribunals to begin with. And for this point, it matters what public perceptions are, because Chris Greenwood, gave us some sense of some deep skepticism, I think, that may be out there facing our international institutions today. And perception matters. And the logical place to start in thinking about effectiveness, I think, is to look at the barriers to entry, to look at the interest of states and how they approach this. And for the most contentious, politically sensitive category of disputes, which I think is intractable conflicts, what we're talking about, there needs to be some recognition that a state's decision to place the outcome in the hands of a third party, a court or tribunal, and Judge Donahue mentioned this, it's a weighty one. States are reluctant to cede control and place the outcome of such weighty conflicts in a third party. The greater the downside risk, the less likely states are to submit to jurisdiction for binding resolution. Now, the assessment of that risk parameter, I think, is key. The decision of states, and I came up with at least 3, there's more, are interrelated factors. So what do we ask? 1, Paul, you know this, likelihood of success, am I going to win? Very important. Likelihood of other forms of resolution that could actually dispose of it. So if there's less comparative negotiating leverage, are there other unilateral measures, trade measures, anything short of military action to get the state there? And finally, one thing that cannot be overlooked is whether there's a sponsor sufficiently highly placed within the government to make that decision, to own that decision. And that's a very human parameter, I think, that sometimes gets lost in that there are many political science studies that talk about governmental decision-making, bureaucracies, how decisions manifest. And it's also the case, as you well imagine, that initiating such proceedings is an enormous amount of political will. And on a human level, a decision to throw down the legal gauntlet publicly and live with the result or settle an unpopular conflict can quite literally cost an official a job. And that's one reason, for example, that you see in some of these large-scale, high-profile disputes, the settlement rates are low. And if you look at BIT disputes, for example, there are structural barriers to be able to get that. So taking a step back, I think that ultimately international dispute mechanisms may not be able to solve everything in the sense of an intractable conflict, but I think there's substantial ways to make progress. And a big part of that is creative ways to lower those barriers to submission. And one important and underappreciated point is defining with clarity and particularity what aspect of the intractable conflict is susceptible to judicial resolution. What is that legal issue? Submitting to international adjudication the ultimate question is a highly politicized, is really a self-defeating starting point. So climate change, Paul mentioned it, is a great example. I can't think of a more globalized pressing issue but so pervasive and diffuse that both cause and effect is really challenging to traditional dispute resolution. The idea of submitting the ultimate question on climate change, I think, is very difficult to conceive, but that does not mean there's no role for adjudication. And I think we've heard in some panels that there are discrete questions of how sovereignty, for example, and the extinction of sovereignty can function with sea level rise for small island states. That threshold legal question, which I think could be susceptible, can then play its way out in the refugee context, in the ITLOS context, you name it. So there is a role to play, and I hope that that's actually a bit of a positive, but always, 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 it's never just legal for governments.
Thank you, Catherine. Caitlin, recognizing that these intractable conflicts are characterized by multiple facets and aspects beyond the legal, and also recognizing that these intractable conflicts could probably profit from a multifaceted approach, how can we give a voice to non-state actors? And I mentioned this, and you've brought this up, because they are often at the heart of the conflict and will probably be necessary to resolve it.
Well, unfortunately, currently, there are very few options available. That's one of the problems. I think that if the international legal community were to expand the jurisdiction of some of their international fora to handle disputes of non-state actors, that would be an important step forward. I think that that the old way of thinking of the world, that conflicts are just between states, is really outmoded. And perhaps it's time to rethink whether some of these fora, such as the International Court of Justice and UNCLOS and other fora that are available, should really be expanded to include population groups that we recognize have certain rights under international law and that should be able to vindicate their rights through these fora, but that cannot do that currently. That would be one important step forward. I think that certain rethinking of certain legal precepts in international law that have been applied so far against the interest of people from non-self-governing territories, such as the Sahrawis, might also be a way forward. For instance, you probably don't know very much about this conflict, and I don't have time to go into a lot of the details, but at one time there was a 16-year war between Morocco and the people of Western Sahara, and that was ended in 1990 when the UN brokered an agreement whereby there would be a ceasefire and there would be a plebiscite where the indigenous people would be able to choose between being incorporated into Morocco or being an independent state. And MINURSO, which was a peacekeeping mission, UN peacekeeping mission, was established. I was sent down to help organize this referendum as a person in charge of legal affairs, and basically, we worked for 9 years and came up with a voters list for a referendum in 1999. And as soon as Morocco saw that that voters list was not in its favor, it just pulled out of the process entirely. And nothing was done to force Morocco to abide by its agreement. Now, I think that if you look at this agreement, it has all the elements of an arbitration agreement, basically. It was a contract between the parties, between Morocco and the Polisario, to have this dispute resolved in a certain manner and outlined the method by which it was going to be resolved. And they employed this method for 9 years. It wasn't as if they said, oh no, we disagree with it. They agreed to do it. There was no disagreement about the criteria that should be applied. And then all of a sudden Morocco decided, oh well, we don't like this voters list because they're probably going to vote against us, so we're going to pull out. I think that if the international legal community were to revisit the concept of how to resolve these types of disputes and whether the dispute mechanisms that have been applied in a number of different cases by the ICJ to these types of cases when they involve state actors can be applied to this type of situation when it doesn't apply only to state actors. This could have been resolved by an international law being applied back at that time very successfully. So I could mention those types of things, but everything that I could mention would necessitate a tweaking of the current system, because unfortunately, the current system doesn't give a mechanism. And one thing that you were mentioning, Peter, the economic aspects of this dispute, well, if you look at what corporations can do, there are several corporations, big corporations now, who are dealing with Morocco in products from Western Sahara. And we've been trying to figure out what can we say to these corporations. And unfortunately, there's very little we can say to these corporations. We can say, you're violating international law. And they say, tant pis. Who cares? All right? We used to have something called the Alien Tort Statute, which was totally eviscerated by the U.S. Supreme Court several years ago. So we can't use that as a basis to bring a claim against some of these corporations. The corporations are totally excluded from the jurisdiction of the ICC for political reasons. What can you do with these corporations? We are trying to go about reaching these corporations in a roundabout way by initiating the suits that I told you about in the European courts to get the European courts to say, no, European countries cannot engage in these practices with Morocco, and therefore it is illegal, and therefore we are trying to confiscate the boatloads of products that are being shipped by these corporations around the world and say, no, you don't have a right to these products, these belong to the Sahrawis, so we're going to confiscate it. But beyond doing that, and that's only successful in the few countries which recognize the rights of the Sahrawis or recognize the Polisario as being a state, beyond that, there's very little you can do, unfortunately. So there has to be a rethinking of how to address the rights of these people under international law in the future, I believe.
Thank you, Caitlin. Now, final question. In assessing the intractability of a given conflict, are we placing too much emphasis on whether or not a given conflict has been submitted to some international dispute resolution mechanism and on the outcome of curial settlement processes? And what is the impact on the system of international dispute resolution when judicial decisions and arbitral awards do not resolve the underlying conflict or are not complied with? Should this be a concern at all in deciding what mechanisms described in Article 33 of the UN Charter should be resorted to in a given case? Should the stakeholders be mindful of the special sensitivity surrounding an intractable conflict before resorting to binding third-party options such as arbitration or adjudication, or in crafting the ruling if jurisdiction is upheld? And in that sense, what lessons can be learned from the conflict between Timor-Leste and Australia, which was recently resolved through conciliation, a non-binding international dispute resolution mechanism? Is that the way forward? Rüdiger?
Thank you very much, Peter. I thought I briefly touched upon it, and I don't want to go into details for obvious reasons. The report of the Conciliation Commission has not yet been finalized, at least it's not in the public domain. But having said that, we should be careful always trying to walk the same street. We should be open for modifications or choosing the mechanisms correctly. Therefore, more use should be made of conciliation and perhaps advisory opinions. The experience of the International Tribunal for the Law of the Sea in this respect is very positive. Here, in respect of Timor-Leste and Australia, there was a treaty between Australia and Timor-Leste which excluded any form of adjudication, the famous CMATS Treaty. The first step, or the second step, if you wish, of this Conciliation Commission was to convince the parties to end this treaty. Therefore, to remove what one could consider the provision concerning intractability. Although we didn't then go into arbitration, rather in conciliation, it opened the way for a more open discourse between the parties and the members of the Commission and the Commission. I wouldn't say this is the only way. This is one of the ways prescribed in Article 33 of the UN Charter, as well as in the corresponding provision of the Law of the Sea Convention. And therefore, one should be open to use these mechanisms more often. And there are other mechanisms, mediation, there are mechanisms of inquiry, they all may solve what I described at the beginning, and Paul agreed, as one of the central elements of a conflict. Remember the famous Dogger Bank case. The facts, after the facts had been put on the table, the conflict was over. And I hope I have your permission, we have in the German legal system in administrative court procedures a particular claim, a particular procedure which concentrates only on establishing the law or the facts. Feststellungsklage. And then one expects that the administration, or it's always an individual on the other side, will fall in line knowing the facts or knowing what the law is. Therefore, I believe we could make use of these more flexible procedures more frequently. Last word. In some parts of the world, it is not considered to be appropriate to drag the respondent before a tribunal. It's not, you shouldn't do that. We should also respect the culture in this respect. And I believe if one pays more attention to that and goes to mediation, conciliation, or whatsoever, one gets better results in some parts of this region. Again, speaking in Germany, in Schleswig-Holstein, we have 3 times more legal disputes before courts than in Bavaria. The reason is very simple. The bars in Bavaria are much more convenient. In Bavaria, people go into a restaurant, a Gasthaus, have a good beer, then they negotiate. And after they have had enough beer and whatsoever, they come to an agreement. This is not the way how it's been done in Schleswig-Holstein.
So parties to intractable conflicts should drink more beer. That's the lesson to be learned here. So that's a takeaway. Paul.
Well,
or maybe I should ask you, you're known to bring these cases, many of them before the ICJ, and Judge Greenwood quipped about it. So the question is, should you think twice before going to an arbitration tribunal or a judicial body?
Well, absolutely. It's a very serious decision with far-ranging consequences, not so much for the practitioner, but for the state, for the client. And one always has to put the client's interests first and give advice based on not simply what may be most convenient in terms of the narrow dispute, but what is most favorable for the client in terms of the overall dispute and indeed the overall bilateral relationship between your client and its neighbors. So I'm not sure, I mean, based on my experience, that it is helpful in the end to refer to certain conflicts as intractable. Looks, as we have seen, may be deceiving. Conflicts may not be as intractable as they appear or intractable at all. And as practitioners, as counsel, we should not shy away from appearances, especially when we have real clients in front of us with real needs and real grievances, and particularly when they have justice on their side. But that said, not every case should be litigated. Some cases lack merit, or in the example given by Judge Greenwood yesterday, they offer no real prospects of achieving their objectives. Other cases may be capable, with your assistance as counsel, of amicable settlement. Whether putting beer on the table helps or not, maybe that works in Germany, maybe in other countries it would be wine or rum, I don't know, but more particularly, your legal skills may still be valuable in helping the client articulate better its position across the negotiating table.
Paul,
And
I think we need to wrap it up.
I just want to wrap up, if you give me a second. So, amicable settlement is, I say this as a litigator, almost always better than litigation. Now, I'm not the first one to say this. More than 150 years ago, a very famous American lawyer had this to say about recommending to a client whether it should go to court or not. Quote, discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good person. There will still be business enough.
Thank you, Paul.
The lawyer,
Who was it?
Abraham Lincoln.
There's the revelation. So I referred to the Rolling Stones earlier in this panel, and I'm very pleased to note that there appears to be no fan of MC Hammer on this panel. And he had a big hit in the 80s. I'm dating myself. Can't touch it. So I think there's a consensus that there are international dispute resolution mechanisms for the taking, and that we shouldn't shy away from using those in an effort to resolve at least the legal element of an intractable dispute. Now, I promised that I would give a voice to the audience, so we're going to open it up for questions from the floor. Please state your name, and a question is preferred over a comment. So keep it short, please, so that we can have several questions from the floor. We only have about 8 minutes left. Thank you. Please.
Thank you. I'm Sun Jin, Dr. Sun Jin from Treaty Law Department, Ministry of Foreign Affairs of China, so I request at least 3 minutes. I speak totally at my purely personal capacity and my personal viewpoint as an international law practitioner and a treaty negotiator in a little larger general international law perspective on 3 comments. The first is about whether there is international conflicts. You would like to use that term conflicts. I prefer not, at least according relation to the South China Sea disputes. There's no international conflicts of South China Sea. If there is one, there will hit the headlines and break news immediately.
Your question, please.
Yes. I think it is when you read our titles, there seems that a source of tensions and potential conflict, examples of conflicts that continue to threaten international peace, security, and human rights. Then, in South China Sea disputes, this is the fake news. So if this first part of the sentence is the fundamental flaw, what's the added value for you to, I quote, effort to use international dispute settlement process to resolve them? Wrong classifications is not likely to have right solutions. I will tell you that the progress of South China Sea situation now is based on the turning over the page of the unlawful arbitration.
Excuse me.
I will not go into that details.
No,
okay, my second point, please.
No, please.
Concerning
please,
the
we
international, sorry about that, the effectiveness. I will refer to the Sir Greenwood has rightly pointed out yesterday at his keynote speech. International law legal framework does not behave the same as the mass court. I think that should be the basic starting point for us to evaluate the effectiveness since the United Nations is not a united government.
Thank you.
And ICJ is not a domestic Supreme Court. If you want to be called a Chief Justice or Justice, don't go to the ICJ.
Okay, thank you.
Sorry about that. I still have my third point.
No. I really have to cut you off here because we only have 4 minutes left, and I would like to give other people
So
the
I
chance.
only need 1 minute, okay? I think there are some
as
restraints
a
for
courtesy-
the mechanisms of the international dispute mechanism. One, you must have some consent of the disputed states. Sometimes the jurisdiction ICJ cases is very manifestly clear. The second point, you must fully and faithfully apply the reservations and declarations of the parties if they make declaration to the relevant conventions. You could not just try to interpret something like military activities or maritime delimitations, exceptions by yourself, and not from the intention of the state, which is a party to that convention.
Thank you. We
The
only
third
have 2
point
minutes
is you
left,
must
sir. Sir,
to
you're
the
taking up
true
all the
intention of the
time on the
parties.
floor. Please.
There is some joint.
Can I ask for a question from that side of the floor, please?
It's a bit difficult.
As a courtesy.
Still, my name is Juan Antonio Yanez, and I am a former diplomat. And for my sins, I have had to deal with the Western Sahara case for almost 50 years. I have even visited the territory as well as the refugee camps in Tindouf. So I understand very well what Mrs. Thomas was telling about. But, and I understand very well also how she put it. But I'd like to put several other points.
Can you just ask one question, please? We only have 2 minutes left. I'm sorry.
It's impossible.
Well,
it's impossible.
I invite you to speak to the panelists
Just
after the
2
panel.
points. Polisario is recognized by the UN as one of the parties to the conflict, both by the General Assembly and by the Security Council. And the Secretary General has a special envoy in facilitating talks between the two parties, as well as neighboring countries, because this is a key feature, the context. Several of the members of the panel have spoken about the context. The context is that there are several countries, plus a regional organization that has not been mentioned, the African Union, in which now both Morocco and the Sahrawi Republic are members. So it's basically a political context that is needed. The only legal aspect, and this would be my question to Mrs. Thomas, do you think that there are certain legal aspects of this overall conflict that could usefully be put to the ICJ, either by the General Assembly or by the Security Council, in order to ascertain the response to these legal aspects? Thank you.
Another question over there. Sir, your name, please?
Daniel Mandel, I'm in private practice here in DC. With respect to enforcement, I was wondering, is it possible to take a judgment from UNCLOS or the ICJ and domesticate it in a national court and seek enforcement as you would a national court judgment from any other country? Has that been done? Or if not, it's my law review article to write, so I get dibs.
Thank you. Final question there. Short, please.
Thank you. Wissam Ahmed from Palestine. I'm a PhD candidate at the Irish Center for Human Rights, where I'm looking at the role of corporations in the Israeli-Palestinian conflict, specifically the economic incentive structure that perpetuates the conflict. And my question is, do you think the existing international legal framework is sufficient to address this economic incentive structure? And if not, what can be done? Things like legal persons and the Rome Statute, or a binding treaty applicable to corporations, which is being discussed at the Human Rights Council. Do you think those would improve the efficacy of the international law applying to our conflict? Thank you.
Thank you. Now, unfortunately, we've run out of time. So I would invite those members from the audience who have asked questions or who still have questions but didn't get to ask them, to approach the panelists during the break and discuss them with them. I thank you for your contributions. I also would like to thank the panelists for their very useful contributions from the 4 different perspectives. So please join me in thanking them.